South Africa's new employment equity targets face another major legal battle. In January 2025, the Employment Equity Amendment Act, EEAA, came into force. One major change is that the Minister of Employment and Labour can now set sector-specific numerical targets for representation of designated groups, which include Black people, women, people with disabilities, in certain job categories and sectors. The targets apply to designated employers, typically employers with 50 or more employees, in 18 economic sectors. Employers have to incorporate these quotas/targets into their employment equity plans and meet them over a 5-year period, September 1, 2025 to August 31, 2030. There are penalties for non-compliance, including loss of compliance certificates, exclusion from state contracts, fines up to 10% of turnover in some cases.
Employers from various sectors will today have to report according to new employment equity regulations. The Employment Equity Amendment Act of 2022 aims to speed up transformation and equity in the workplace. The Act gives the Minister powers to set numerical targets for specific economic sectors. There have been legal challenges to these new regulations by the DA and some labour unions.
Democratic Alliance, DA, the main opposition party, which filed a constitutional challenge. Business/employer lobby groups, especially NISA, National Employers Association of South Africa, and Sokeliga. Their main legal arguments include unconstitutional quotas. The targets are said to be rigid, inflexible, and mandated by the state rather than being voluntary or flexible, which opponents say could violate Section 9 of the Constitution, right to equality, by unfairly discriminating. Procedural flaws/consultation issues. The challengers argue the minister did not follow correct administrative processes under laws like the Promotion of Administrative Justice Act, POJA, or adequately consult stakeholders, or do proper impact assessments. Wrong constitutional tagging of the bill. The DA claims that because of the nature of what the bill does, affects provincial interests, etc., it should have been dealt with under Section 76 of the Constitution, not Section 75. If improperly tagged, it may be procedurally invalid. Potential harms to business and employment. Opponents argue the targets will raise costs, possibly lead to dismissals or restructuring, deter investment, and may worsen unemployment.
The Democratic Alliance is challenging the Employment Equity Amendment Act at the High Court in Pretoria today. Let's cross over to that and listen in.
Implemented in a manner which amounted to job reservation and quotas, because if it was, it would fall foul of what the Constitution requires. We are not at that stage for the reasons I've explained. We are at the anterior stage. We're looking at this without reference to any particular complainant before you. The court appreciates that. So we are looking at it from a, maybe called an abstract challenge. But there's nothing wrong in doing that, because if the legislation is of the sort we say it is, then it falls foul of the Constitution. Not because of its application, but of its conception. Now that is dealt with, milady.
An urgent application by NISA and Sokeliga to interdict, i.e. to block, the implementation of the sectoral numerical targets was dismissed by the Gauteng High Court in Pretoria. The High Court held that the minister's powers to set sectoral targets were lawfully exercised after gazetting the targets in April 2025, and that the applicants did not show sufficiently substantiated harm to justify an interdict. The court also emphasized that until a full judicial review, i.e. full hearing on all issues, happens, the targets are valid and binding. What the DA is challenging. The DA is specifically challenging Section 15A of the Employment Equity Amendment Act, which gives the Minister of Employment and Labour the power to set numerical targets, sometimes called sectoral targets, for representation of designated groups, Black people, women, people with disabilities, across occupational levels in various sectors. The DA's view is that these targets are not just voluntary goals but could amount to rigid quotas, which they say will lead to unfair discrimination, job losses, and violate constitutional protections. Key legal grounds/arguments by the DA: violation of the Equality Clause, Section 9 of the Constitution. The DA argues that the mandatory targets could amount to unfair discrimination, especially against groups such as colored or Indian South Africans in certain provinces, because they may find it difficult to compete under those numerical targets. They contend that the law replaces a flexible system, where employers could set goals relevant to their own workforce, with a one-size-fits-all system imposed from above. Incorrect tagging/procedural errors in Parliament. The DA says the bill was mis-tagged under Section 75 of the Constitution, when it should have been under Section 76 because of how it affects provinces. If that is correct, it would mean provinces had insufficient input, making the law's passage procedurally defective. They argue that this mistagging could render the Act invalid because the Constitution requires that laws affecting provinces have proper procedure, which S76 ensures, including participation via the National Council of Provinces, NCOP.
The Labour Minister's lawyers have argued that the DA's understanding of the Employment Equity Amendment Act is misguided. The party today challenged the constitutionality of the clause which allows for the executive authority to set targets for companies. This is in 18 economic sectors.
Overbroad/vagueness/ministerial power. The DA argues that Section 15A gives the minister too much discretion and power without sufficient limits or clarity. There are fears the minister could impose mandates that are not responsive to local or provincial realities or business conditions. Also, that the targets could force employers to let go of people, refuse to hire people, or otherwise discriminate by race or other designated categories if they don't meet them.
Lawyers representing the DA argued that applying blanket employment equity targets nationally, when the racial and gender demographics in provinces differ, is why it's challenging Section 15A of the Employment Equity Amendment Act. The party says this would cause barriers to work and amounts to a quota.
The actual judgment in DA's case is still pending. As of last reports, no final decision. Depending on how the court rules, there may be appeals to higher courts, maybe even the Constitutional Court, especially if constitutional invalidity is found. The precise limits of the ministerial power, how reasonable grounds to deviate from targets will work, whether or how provinces are sufficiently considered, how non-compliance will be enforced, etc., are still likely to be litigated. It seems the battle will go on for a while as none of the parties involved are willing to back down. What is your opinion? Thank you for watching. Please don't forget to like, share and subscribe.